This is the current federal tax developments for the week of June the 8th, 2026. Current federal tax developments are brought to you by your state society of CPAs. I'm Ed Zollers, and we're talking this week about various things that went on during the week in taxes. So first, we're going to look at proposed user fee increase for estate tax closing letters you should be aware of. Next, we're going to compare two recent and conflicting court decisions regarding the causation standards or partial shutdowns for the Employee Retention Credit, the ERC. Then we'll discuss a tax court decision highlighting the extreme risk of relying on speculative land use for conservation easement valuations, a topic that the tax court keeps coming back to. And so far, we're still looking for somebody to win on one of these, and we haven't found that entity yet. Following that, we have a bench opinion dealing with the substantiation issues and a flawed carryover theory for mortgage interest deductions pursued by a CPA. We'll also cover a recent decision on immediate taxation of cryptocurrency staking rewards, one of the first key tax court decisions in this area. Finally, we'll review IRS Notice 2020-636 expansions of covered employees under Section 4960, and we'll end with an 11th Circuit ruling on FBAR compliance, willfulness, and the limits of an IRS agent settlement authority, as well as whether there's an Eighth Amendment constitutional issue involved in the FBAR penalties. So our first development today concerns a notice of proposed rulemaking from the IRS and Treasury Department that will directly impact practitioners and executors who manage decedents' estates. The proposed regulations aim to adjust the user fee required to obtain an estate tax closing letter. And this will be Regulation 103-193-26 issued on June 1st. The core change proposed here is an increased user fee for an estate tax closing letter, or IRS Letter 627, from the current rate of $56 up to $20 more, $76. As many of you know, the fee has fluctuated in recent years. Back in 2021, the user fee was set at $67, and it was actually adjusted downward to $56 following a cost model review in 2023. Until these proposed regulations are finalized, the $56 fee remains the effective rate. The reason for these changes isn't arbitrary. It is driven by the Independent Offices Appropriations Act and the OMB Circular A25, which legally require federal agencies to review their user fees biennially and to ensure that they are fully recovering the cost providing services that confer special benefits onto identifiable recipients. So, yeah, we have those kind of things coming in. So how did the IRS arrive at the $76 during its 2025 biennial review? Well, they first utilized a comprehensive full cost calculation. First, they determined that the total annual operational costs maintaining the estate tax closing letter program had risen to approximately $615,593. This cost encompasses direct labor from GS5, GS8, and GS11 level staff who handle the initial processing of the requests, as well as higher level IR10 and IR06 pay band professionals who conduct quality assurance reviews. A significant driver of the cost is a massive overhead allocation of 62.92%, which IRS taxed on to cover indirect expenses like IT, human resources, rent, and general administration. Ultimately, they reached the proposed $76 fee by dividing the total program cost of $615,593 by an estimated annual volume of 8,053 requests. So now let's look at the mechanics of what this fee actually funds. The program allows authorized persons to request an official letter, IRS Letter 627, confirming that the estate tax liabilities have been fully addressed. The internal processes involved involves initial process, and preparation by GS level staff, followed by a quality assurance sampling process that checks for proper authorization, accuracy, and correct addressing. Interestingly, the IRS noted in the proposal that this increase will not have a significant economic effect on small entities, primarily because most decedents' estates do not meet the definition of a small entity under Title V of the United States Code, Section 6016. However, from a practice management standpoint, the increased cost is an unavoidable administrative cost that we must factor into the client's overall estate tax settlement budgets. So it's going to cost you $20 more. Just keep that in mind. So question comes up now effective dates. When do we need to start charging clients the higher fee or start paying the IRS the higher fee, as the case may be? It's important to note that these regulations are currently proposed, not final, and Treasury and IRS are still seeking public comments. If finalized in their current form, the trigger date for the new $76 fee will be for users' requests received by the IRS on or after 30 days following the date the final regulations are published in the Federal Register. As an action item, practitioners handling estate administration need to monitor the Federal Register closely so that, in essence, you get the right payments made. In this case, once that 30-day clock begins, we understand there are going to be changes, and probably at least some clients would like to save $20, and there are clients even with large estates that will really like to, save that $20. You'll probably be pushed a little bit to try to get that request in, assuming that everything has taken place. It would allow us to make that request. Again, we have our infographic here for you to look at. Essentially, this provides a visual summary to share with your teams, etc., regarding the estate letter fee changes we've just discussed. You can see the historical rates. It was $67 dropping down to $23 based on or should say $56 based on a 2023 cost model, and now it's going to spike back up with a $20 change. My suspicion is part of the reason for this kind of change deals with just the sheer variation in the number of requests they're going to get, and that's causing a problem. Only 6,000, basically the small number of requests we had here is just not going to, basically always be consistent, while that funding will run up and cost more. And it's probably not, in fact, incredibly unlikely that the reduction in IRS staffing in general, well, probably not impacting how many are here, could cause more overhead to get passed into this program, right? So since we have 8,053 requests, that's how we get our $76 price point. Next up, we have a pair of cases. The first one is Northeast Health Services, LLC versus United States, case number 24-20960 from the Federal Court of Claims issued on May the 28th. And then the second one is Tri-State Memorial Hospital versus United States of America, case number 2:25CV00181-TOR. This one came from the Eastern District of Washington, both coming on May 28th, 2026. If you're dealing with ERC credit appeals, right, audits currently going on, or if your client is considering litigation, these are the first couple of decisions we have that are totally on point related to what exactly would be a partial suspension of operations. Now, that's the good news because, we've had a lot of cases of various ERC consultants trying for the home run decision, right? A decision where they're hoping that they could get the IRS notices invalidated, which always got me like, yeah, but there's still got to be some other decision about what the law is there. But their hope was that if they invalidated them, the court would also say the IRS just has to pay everybody, which seemed to be the only way this worked. Not surprisingly, the courts didn't go for that. But this now looks at the actual facts of two real cases and decides whether or not they qualify for the employee retention credit. However, you're expecting consistency. We don't have it with these two cases. Right? So, in essence, both of these courts are attempting to interpret the exact same operative phrase in the ERC statute. What is considered due to a partial suspension of operations due to a government order, right? Specifically, is an operational disruption legally due to a government mandate? Before we look at how they split, it's worth noting that what they agree on. Both opinions acknowledge that the phrase due to is inherently ambiguous in common law and tax jurisprudence, okay? With interpretations historically ranging from a contributing cause all the way up to the sole and proximate cause. More importantly, for practitioners, both courts completely reject the idea that general pandemic conditions or inherent COVID-19 risks alone can trigger eligibility. They both require the suspension must be explicitly and legally linked to a specific external government mandate. Which, by the way, with some of the reports I've seen from some of the, consultants out there, it's like, what government mandate exactly are you linking this to? It's like that is a key. Both courts want to see that. So that's a big one. However, where they part ways is where that link requires a low bar, but for causation. The shutdown, would not have occurred but for a government ruling mandate or a much stricter proximate cause. In essence, that's got to be the overwhelming reason why it happened, right? There's all those other issues. So let's start with the first case, which is Tri-State Memorial Hospital, which comes out of the Eastern District of Washington. This case, the judge adopted a highly permissive causal test by looking to establish civil litigation principles. The court interpreted the statutory phrase due to as meaning simply because of. That's a very low factual bar. It's the but for causation requirement. For the taxpayer, what this means is if you can demonstrate the operational disruption would not have happened but for the order, in this case, Proclamation 20-424.2 from the state of Washington, the basic causal link is satisfied. Even if other factors contribute to the disruption, the court found the plaintiff provided sufficient plausible facts to survive the government's arguments for pushing for a proximate cause standard. The focus here was on whether the facts were sufficiently connected to the mandate to be deemed plausible for litigation. But again, they're facing a much lower standard. It just has to be that essentially, if this particular order had not been issued, then the shutdown wouldn't have occurred. Now, contrast that with Northeast Health Services decision out of the Federal Court of Federal Claims. This case established a significantly higher and much more rigid barrier to entry. While acknowledging the debate over the ambiguity of the phrase due to, the NEHS court focused heavily on statutory immunity and proximate cause. This court ruled that the government's mandate must be the true and active source of the suspension. Merely being a contributing factor is entirely insufficient. More critically, the court applied a statutory exemption analysis. Because Northeast Health Services were legally classified as an essential service, they were exempt from the mandate. Therefore, the court reasoned the government order legally lacked the power to mandate operational change in the first place. While the government recommended that certain steps be taken by a business like this, those recommendations did not rise to the level of a legally enforceable mandate. Nobody could be fined, imprisoned, put in jail. Nothing could happen if they didn't follow it. Well, suggested that was it. So if you have statutory immunity, which is what this court ruled, regardless of how severe the mandate cannot be the proximate cause of your suspension. You made a decision, right? Regardless of how severe the pandemic disruption actually was, obviously with the except for if you had a drop in revenue sufficient to trigger the other test. And, in this case, in the Federal Court of Claims, the court here was very much interested in saying they believed if you used a but-for test, then the whole drop in revenue part of this was irrelevant. In essence, that was meant to cover businesses that were impacted by something other than, being forced to shut down because the government said shut down or we're fining you, we're going to throw people in jail, we're going to do whatever. That's their theory. So how do you deal with, this conflicting precedent? These two cases offer wildly different hurdles for establishing a valid ERC claim. The tri-state standard provides a highly useful guide for establishing how a claim through factual plausibility anchored by a low causal standard. And certainly if your client is in audit right now, right, or you're in appeals, you're going to argue the tri-state standard is what should be used. However, the NEHS ruling serves as a stark warning. If your client's industry was deemed essential or was otherwise exempted by law from the specific government directive, attempts to establish eligibility under the partial suspension test will face a huge uphill battle. So, looking ahead at IRS audits, you can expect examiners to lean on the NEHS proximate cause standards to reject essential businesses. And I would expect that unless, and if the government, is the government going to, I shouldn't say government, is the taxpayer going to appeal the NEHS decision? And if they do, that could cause an interesting issue because the appeal would go to the federal circuit. The federal circuit has nationwide coverage. Now, if the government appeals the tri-state appeals, I should say, the Tri-State Memorial Hospital, you got to get them in the right order, case, that would go to the Ninth Circuit Court of Appeals, which while that would be important for, any clients I have because I'm sitting here in Arizona, my clients in Arizona, which generally they are, might not make much difference for those of you, who are sitting, let's say, in Arkansas, not exactly going to yet be telling us how to make the call for there. But this is kind of an interesting area. Again, we have in our slides and on the screen, if you're watching the video here, our, infographic talking about the two different approaches here. And again, we don't know if the but-for or proximate cause approach will ultimately win the day. I do expect, as I said, the IRS, though, is going to be arguing for proximate cause. And the reason why is because they know you got to take them to court if you don't want that one. And their theory at this point is that, we don't know if a court's going to back you. Right? And I think that's probably going to continue to be their position. Now, if your client's willing to litigate, then the IRS has to worry a lot more about Northeast-South services. And I think that's a case where, you don't want other courts following that one if you can avoid them. So it is one of those interesting asides. Now, other interesting aside about this, in the case of, Tri-State Memorial Hospital, they had their claim rejected by the IRS, meaning the 2-year clock was running. And so their appeal, they basically filed in court because they had to. Otherwise, they were going to give up, I believe it was about a $2 million credit. Now, Northeast Health decided to push the matter because the IRS hadn't decided on theirs. Rather, they went to court based on the 60-day rule, which almost certainly everybody with a pending, not yet ruled upon claim for the employee retention credit, they filed in time to get it in the list, to get it in, so they got the statutes covered. Almost everybody is going to meet that one right in another 60 days. This also illustrates what some attorneys have pointed out to me, that there's a risk. The 60-day rule is great. And I realize we're talking about a lot of money in both these cases we were. But there's a risk of taking a case to court. In fact, a number of attorneys I've talked to indicated that if we were talking about a suspension that was due to, essentially, or let's say not a suspension, but a drop in revenue case the IRS isn't ruling on, and, the facts are all there, that one makes great sense to go 60 days in the court. But they really said you have to think long and hard about taking a case as partial suspension to court. Because until you know the IRS has rejected you, which Tri-State knew, right? So there is a bit of a risk here because now having gone to court, IRS doesn't control this case anymore. In fact, IRS appeals, and we talked about that a little while back, once you filed this, in court, we had an ERC case on this, where they filed a court case and then the IRS decided to approve the claim afterward. Now, sorry, they don't have jurisdiction once you filed. So now we're at Department of Justice, who wanted to keep fighting. So that is a risk to keep in mind. If your client just, we've got to do something, I want to get my money. True, but you might get on the record a decision that's not going to be well for you, which then means you're going to have to either take it up to the Court of Appeals or you're just going to have to accept that you lost. But you essentially got things going. If your clients had a denied claim of any sort, it's been denied by the IRS. He was just on that, that automatic denials that they were running with. That's a denial. 2-year clock's running. That's a whole different decision. You need to do something before 2 years is out or game over. So next, we're going to shift gear to the third development, which deals with non-cash charitable contributions, conservation easements, and the extreme risks of aggressive valuations that we've talked about before. In Rising Rock Partners LLC versus Commissioner, the U.S. Tax Court addressed the limits of valuation methodologies for conservation easements in a situation that should sound very familiar. The court heavily scrutinized an appraisal that relied on speculative industrial rezoning, an income approach based on a hypothetical granite mining. Yes, we're in Georgia still, right? To justify a massive multi-million-dollar deduction. If you haven't noticed, the granite mining bit is very popular for people that found properties in Georgia to make the argument there. As we're going to see as we discuss this case serves a stark reminder to tax professionals. When evaluating the highest and best use of property, the tax court is going to look past theoretical economic potential and focus squarely on the practicality of legal permissibility. Can you do it? Is there any reasonable chance you'd be allowed to do it? And the actual reality of the market. I don't care that theoretically it could take this much out and sell at this price. With that much more product coming on market in that area, essentially manage to drive down the price where it wouldn't be economical any longer. Okay. So let's talk about the factual background of the Rising Rock Partners case. In this case, the litigation involved the 2017 tax year non-cash charitable contribution deduction where Rising Rock Partners, RPR, when you'll see referenced here, claimed an immense deduction of $12,765,000 for granting a perpetual conservation easement over 226 acres in Meriwether County, Georgia. The taxpayers predicated this massive valuation on the assertion that the report value of the property was exceptionally high due to its potential to be used as a commercial granite quarry for mining. Right? To support this, they relied on expert testimony using discounted cash flow models to project substantial future income from mineral extraction. Note, there is no mine on this property. None of this exists right now. Okay? However, the IRS disallowed these deductions entirely and asserted the gross basically overvaluation penalty under 6662. Okay. Now, when evaluating these types of deductions, the court begins by reaffirming the taxpayer bears the burden of proving both entitlement to the deduction under Section 170 and the fair market value of the donated easement. And they cited the Endopco decision for this purpose. The court applied the standard of before and after method, which is the standard we always use in this case, right? For a conservation easement. It requires determination of the property's highest and best use. And then we determine what's the value of that property prior to granting the easement. And then with the easement granted, which in this case is they're going to argue gets rid of the highest and best use as being possible to be used in the property. What's the new value? And the difference is, how much value did we gift with our easement? That's going to be there. Now, citing Ranch Springs LLC, a case we discussed earlier, the court stressed that this use must be reasonably probable use that is legally permissible, physically possible, financially feasible, and maximally productive. Crucially, the court noted that a property's current use is presumed to be its highest and best use, absent contrary evidence, relying on the case of Olson versus United States. And explicitly excluded uses dependent on uncertain future events or contingencies that are only theoretically possible. This is where we are going to get into some problems with this valuation. You apply those standards, the taxpayer's reliance on a hypothetical mining operation was found to be both legally and economically unsound, invalidating the valuation. First, there was one major legal impediment. The property was zoned for agricultural and low-density residential use. That explicitly prohibited quarry mining or other industrial uses. The judge noted a critical lack of effort. Now, this one is a little unique. To change this, pointing out that over a year of ownership, the parties never even attempted to obtain a rezoning, text amendment, or special use permit for the property. It's frankly illegal. It's never been legal to do a granite mine there. Now, this is interesting because earlier courts have discussed more the possibility of, is there a reasonable chance it could change? But this court said, you know what, if it's reasonably possible, you would have tried. Because, and I think this is inherent in the assumption, considering how much more it was worth than you paid for it, why in the heck wouldn't you get it rezoned and sell it? Right? We have trouble believing you're truly this charitable. Second, there was a fatal economic flaw as well, ignoring even the zoning problem was solved. The taxpayers' experts made an unsupported assumption the local market could absorb the additional granite supply, completely ignoring that existing local quarries had unused capacity. They aren't taking granite out of the ground at the rate they could. And the transportation economics heavily favored those established competitors. You'd have to haul it further, right? And those people still have capacity. So they could put more product on the market. So you're essentially flooding a market with a product that's going to cost you more to get out. That's not a prescription for actually having a successful business. So the court concluded that quarry development simply was not financially feasible for any hypothetical willing buyer. And therefore, between these two uses, this can't be your highest and best use case. Right? We've gotten that out. So having rejected this is how the court approached the valuation methodology. The speculative discounted cash flow models, the court turned to the market approach to find a true value. This is where we always end up on these things. The court determined the absolute best, most persuasive evidence in the record was the arm's length sale of this exact subject property that occurred just 13 months prior to donation. And guess who the buyer was? The partnership. Based on this recent sale and other comparables, the court adopted a valuation of $3,900 per acre. This dropped the allowable conservation easement value down to only $639,955. As you can see, that's way less than the $12.76 million deduction that was initially claimed, which raises a huge problem with the gross valuation misstatement penalty. And that's what we turn to next. Because of this huge difference, the court then addressed Section 6662 and its actors-related penalties, and specifically the gross valuation misstatement penalty. The judge ruled that because the claim value exceeded 1,900% of the correct value, it constituted a gross valuation misstatement under Section 6662H. This classification is absolutely devastating for the taxpayers in this case. As the court highlighted, statutory reasonable cause and good faith defenses are absolutely unavailable for gross valuation misstatements attributable to a charitable contribution property under 6664C3. Consequently, regardless of the fact they relied on experts or whatever they want to claim, none of that's going to work. 40% additional add-on to the tax is mandatory. This is an extreme risk of relying on appraisals built on non-permissible speculative land uses or any sort of appraisal for a charitable contribution that appears to be on the very aggressive end. At the very least, you want to make sure the appraiser understands that. You want to make sure the client understands that. And you want to make sure that the appraiser tells the client, hopefully, why they believe there's no risk that a court could ever find that this thing was worth less than half of what they had originally, what they claimed on the return. My guess is you're not going to get an appraiser to write that letter. And that, at that point, well, look, they're not willing to say that's not going to happen to you. So let's just presume it would, right? They don't want to go out and say, if their valuation is that good and that solid and really is, ironclad, which they're telling you, and why aren't they willing to stand behind it? Key question. Again, we have another one of our infographics in this case. It summarizes the whole disaster of an outcome here, right? We have a huge valuation discrepancy on the left side. Its speculative binding model yielded a claim deduction of over $12.7 million, while the court, using market reality and a recent arm's length sale, dropped that value to just under $650,000. That killed, in essence, the deduction and got the penalties in play. And there were fatal flaws in the highest and best use, right? There were legal and zoning barriers, and there was economic infeasibility. Either one by itself would have tanked the valuation. The fact they had two just makes it worse. So next we turn to the fourth development, a bench opinion that attacks a fundamental yet occasionally misunderstood aspect of mortgage interest deductibility. Also indicates that, just kind of reasoning off the top of your head about what you think the tax law is will not necessarily go well even for a CPA who's been doing tax work. This is the case of Ingboak versus Commissioner. This is a bench opinion from the tax court, docket number 12275-24. It was issued on June 3rd. In this case, U.S. Tax Court evaluated whether a taxpayer could claim a deduction for interest that was neither paid nor accrued during the relevant tax year. Which, by the way, also gets us to clients who think they can delay. Well, if I didn't deduct it last year, I'll deduct it this year. Yeah, it doesn't work generally either. This is a reminder of the heavy burden placed on taxpayers to substantiate the deduction. What makes this case particularly notable is that the taxpayer advancing these substantiated carryover theories was actually a CPA with decades of tax experience. Okay, let's talk about this case, the background of the decision. The petitioners are Henry Ugbach, right, and Clara Ugbach. The year at issue was their 2021 tax year. Now, Henry is a CPA with over 30 years of tax experience. In July of 2020, the taxpayers refinanced their mortgage deductions through a new lender, Cenlar. The records clearly show that their previous loan with Select Portfolio Services, SBS, was paid in full as of July 28, 2020, with no payment of any kind occurring after July of 2020. During the 2021 tax year, Cenlar reported $18,411 in mortgage interest paid on 1098. Yet, the taxpayers claimed a significantly higher deduction of $40,200 in return, a difference of over $21,000. Where'd that extra interest come from? So, where'd it come from, and how did the CPA justify this excess deduction? Well, the taxpayers provided the court with what they called a substitute form 1098, and a letter purportedly from SBS stating that $31,635 had been paid in 2021. Now, as you might guess from the court using the terms, allegedly, a purportedly letter, and this, what they called a substitute form, that the court had doubts, which they expressed very clearly, about whether these were actual forms from basically from the lender. But the justification was an alleged carryover mortgage interest. Now, Henry argued that because he was unable to deduct the full $71,618 of interest paid in 2020, a representative from SPS allegedly advised him he could simply carry over the unallowed portion and deduct it in 2021. Essentially asking the mortgage for relief to treat unallowed personal mortgage interest from a prior year as deductible in a subsequent year. Okay, couple of problems here, obviously. First thing is, you should realize if you are a CPA, EA, or whatever, you go to court, and even if some random person with a lender told you can do something, you really have a requirement to do your own due diligence and assure that exists. Why? Just because the banker said you could doesn't mean you can. Banker is not allowed to write U.S. law, right? And you are in a really bad position to say you relied on that because you supposedly have been trained to figure out what the law is, which he didn't. And that turned out to be a mistake, shall we say, in this case. Now, let's talk about the statutory framework for deducting interest, because the court wasn't buying his theory, right? Under Section 163A, the law allows deduction for interest paid or accrued within the taxable year on indebtedness. Taxpayer, as a cash basis taxpayer, it's going to be paid, not accrued. Right? While personal interest is generally limited under Section 163A, the qualified resident interest exception does apply to mortgages. However, the court said there's the core requirement here. The interest you're going to claim on Schedule A must have been paid or accrued within the taxable year. That's absolute. And so for a cash basis taxpayer, like the ones in front of the court here, the court cited the case of Smoker versus Commissioner, reiterating the taxpayer absolutely cannot deduct accrued but unpaid interest until after the obligation is actually discharged. This isn't what they're trying to do, but it's like, doesn't matter, right? You cannot deduct it until you have, done it. So there's no theory. Cash basis taxpayer, what'd you pay this year? What he paid this year is what was on the 1098 from Cenlar, not this theoretical amount that he was disallowed the prior year of the interest, right? And also, this is now the court, as I mentioned, took a look at the substantiation. And the taxpayer had some severe issues. The judge expressed, quote, in the opinion, severe reservations about the authenticity of the petitioner's documents. Upon closer inspection, the supposedly 2021 substitute Form 1098 appeared to be simply an altered photocopy of the legitimate 2020 Form 98 with SPS, with the year manually changed and irregular photocopy markings present. In essence, they mocked it up so it looked like 21. Making matters much worse, the record keeper for SPS testified under oath that these documents did not exist anywhere in their files. The lender did not have any record of this. Now, remember, if it was somebody at SPS, I'm sure, either you need to go back and get them to come down and testify for you and say why it did exist, right? And what was there. Or if you just didn't take their name down, then yeah, you're dead in the water at this point. We don't have anything. So the court simply decided the documents were deemed inauthentic and created specifically for the purpose of supporting a fabricated deduction. Bottom line, they didn't buy your story, right? They're thinking that this doesn't make sense. So finally, to put the nail in the coffin, deduction, the court looked at the legal merits carryover argument. During trial, Henry admitted that taxpayers had no outstanding loan with SPS in 2021 and consequently paid no interest to SPS in that year. The court pointed out a simple truth. Because no debt existed, no interest could possibly have been either paid or accrued. It doesn't matter if it's a cash basis or not. Furthermore, the taxpayer entirely failed to identify any statutory authority, such as Section 163D2, 163H4F, or Section 461G, that would permit the carryover mortgage interest under these circumstances. Find me the carryover rule. It's got to be in the code, right? Ultimately, the court ruled the taxpayers failed to meet their burden of proof under Tax Court Rule 141A, and deduction was entered in favor of the IRS, completely denying the excess deduction. So again, why'd the mortgage carryover fail in court? This is our infographic, again, on the slides. You can find it at Current Federal Tax Development's website on the weekly and audio and video updates. You can download them from there. Or they're on the screen if you're watching the video here. This is a summary of the case and everything that went wrong, which was a whole bunch in that case, right? On the left side, we have factual and evidentiary failures, highlighting use of fraudulent, altered documentation, and fundamental absence of an underlying debt during the tax year in question. On the right, we outlined the legal and statutory misinterpretations. Specifically, the carryover fantasy lacked any support whatsoever in the IRC, the violation of strict cash-based deductibility rules, and notable fair professional standards by a CPA with 30 years experience who advanced these meritless claims. As a CPA or EA or attorney, you're going to be held to actually, finding support. Where is the support for your claim? Again, the court might have had taken a more favorable view if this person had not been a CPA, didn't have any training, and had been able to bring in somebody from the lender who admitted they had said such a things. You might have gotten a little leeway, but in terms of not getting the deduction necessarily, but at least not being on the line for penalties and all the other kind of stuff we get stuck with here. Unfortunately, in this case, as a CPA, an EA, or an attorney, you're supposed to know how to go get the law, right? And you are required to understand the law. This is not optional, right? Especially on your own return. Well, next up, we have a case on cryptocurrency staking rewards. And we've had one, kind of that was tried to force through. Remember, District U.S. District Court in Tennessee, basically, I think it was a little over a year ago, that they tried to force it through to get a ruling on staking or a ruling where the IRS position was correct or not. But we have an actual case now that actually where they could go forward. I remember that was the one where the IRS just gave the refund, and therefore they couldn't get a ruling. But this is a case of Pascal versus Commissioner, TC Memo 2026-46 case, decision issued on June the 4th. So we're now with digital asset space, right? In Pascal versus Commissioner, the tax court issued a significant memorandum decision regarding taxation of cryptocurrency stake and rewards under Section 61 of the IRC. Now, it's interesting because it's the first one of these I know is out there. I will caution you, though, this is a pro se case, which means the taxpayers represented themselves. So with legal representation and maybe some more thought given to actually how to argue the case or what code provisions to use to argue the case, you might get a different result, but this at least is the initial view that we've got here. As the IRS continues to ramp up its enforcement on digital assets, it helps understand when and why the court considers stake and rewards to be taxable income upon receipt. That helps you explain crypto-involved clients why they need to pay tax on their staking rewards. Okay. So, if you're not aware, staking is something used more recently in cryptocurrency, where you basically instead of going through the whole bit of performing work and solving a math problem, and in order to update the blockchain, and then if everybody approves if basically a majority of other people who are checking the blockchain approve your update, then you get some cryptocurrency issued to you. That's proof of work. We moved to a proof of stake because proof of work became very, very, very expensive. Would have been even more so with the AI demand for basically the graphics cards, which is what we're really great at doing those math problems. So we went to staking. What staking says is you pledge so much of your shares, of your crypto. So you're going to pledge a certain amount of crypto to go into this pool that updates the ledger. And then randomly, we're going to choose somebody who's in the staking pool based on, relative amounts. Your chances of getting picked are higher. The more you have in, we're going to randomly pick somebody there to update the ledger. And if everybody approves, then we're going to pay them. A lot of times this goes in with, let's say, from a crypto brokerage firm that, that's custodial, holding them custodially. They will pool their clients' funds, get a staking amount, right, put in the staking pool, and then they'll pay the clients based on the fact that, their pool got done. Everybody who's in the pool gets a return. That's kind of what happened in this case, right? So again, in this case, the tokens they had were staked via a proof of stake protocol for all of 2021. As a result, additional tokens in the crypto, they're in Cardano. Not exactly one of the more popular cryptos, but hey, out there, that's what they had at the time. And which were indistinguishable from the existing tokens, were credited to Mr. Pascal's account on a monthly basis. A key factor here is that eToro, the custodian, temporarily restricted the transfer of these tokens to external platforms because they intended to delist Cardano. They're getting rid of it, right? However, despite these transfer restrictions, it was established that Mr. Pascal maintained the uninterrupted ability to sell the tokens for cash on the platform at any time. The total value of these rewards reported to the IRS via Form 10 MISC by eToro was $33,354. Right? Now, the taxpayers had three pillars of an argument as to why they shouldn't pay tax on the $33,354, because they didn't include it on their return. First, they argued a lack of domain and control, asserting that eToro's transfer restrictions prevented them from fully owning the asset. We were restricted. We couldn't do anything with those tokens we were rewarded because we couldn't take the tokens out. We couldn't transfer them. All we could do was sell them, right, in that case. Second, they attempted to classify the rewards as non-taxable accretion in value, arguing they're analogous to a pro rata stock dividend under the famous Eisner versus McComber Supreme Court precedent. Third, they posit an interesting theory that the rewards were self-created property. I've heard this one multiple times. comparing themselves to a baker making a cake or a writer drafting a book. So yes, the assets can only be taxed upon realization through a later sale of the crypto. So let's take a look at this. In evaluating the question of was this income, the court relied heavily on the principle of dominion control. Relying on the Supreme Court case, Commissioner versus Glenshaw Glass Company, the court reiterated that gross income broadly includes all accession to wealth over which the taxpayer exercises complete dominion. Now, the taxpayer tried to say, I can't transfer the tokens, right? That's my defense. Because eToro restricted them from moving the tokens to an external wallet, including one they held personally. They lacked true ownership and control. But the tax court rejected that defense, pointing out that because Mr. Pascal maintained the ability to convert the tokens into cash on the platform at any time, his access to that wealth was entirely unimpeded. Citing Supreme Court in Helveling versus Horace, the judge noted the fundamental rule: power to dispose of income is equivalent to the ownership of income. So, can't argue you had dominion and control. The court also didn't like the other two arguments any better. First, the taxpayers tried to claim that these were like stock dividends, right, under the Eisner case. The flaw in this argument, though, that was fatal per the court, is that a true tax-free dividend takes nothing from the corporation and adds nothing to the shareholder. You own basically 0.005% of Microsoft the day before the stock dividend, and you own 0.005% of Microsoft the instant after the stock dividend. Nothing changed. They merely gave you an extra piece of paper, but nothing changed when you do that, right? So there was no accession to wealth. In contrast, the court noted that Cardano rewards actually increase the taxpayer over a proportion of outstanding tokens. So let's assume the Cardano tokens were worth, X in total. Well, they had a bigger chunk of that X now because they had more tokens. So therefore, they had an accession to wealth. Third, let's go to the third case. What about the baking a cake theory, the self-created property theory? The court said while a baker or writer actively manufactures their products with personal labor, a crypto staker does not. This is utterly passive income. The generation of new tokens is entirely driven by an automated protocol process. Because the taxpayers lack the personal power to decide when or if the property was created, they couldn't claim it was self-created property, thus rejecting the third tier of this one. Right. So the final termination on staking and control. Ultimately, the court handed down a final determination that the staking rewards were indeed taxable upon receipt in the year they were credited, which was 2021. The fair market value for the rewards is fully included in gross income. Important note for practitioners is the judge arrived at this conclusion by relying on fundamental application section 61, which is very broad and established realization under case law, noting that they did not need to rely on the IRS revenue rulings issued after 2021 to reach this result. Because what the taxpayers also tried to argue that the IRS's, rulings eventually that came out and eventually one that established or took a position that staking was taxable income, that had been issued till after 21. So therefore, they aren't bound by it. The court said, we're not binding by that because actually that's probably not binding anyway. Rather, we're binding you on the concepts of law, which, by the way, we happen to agree with the IRS on, that they actually did get that right in that ruling. And the law was still there in 21. You're responsible to follow the law. So if your client has the ability to liquidate their staking rewards into cash, they have triggered an immediately taxable event upon receipt. And certainly the service is going to take that position. Okay. Now, again, will we see somebody, let's say, who is represented try to make arguments here? Maybe. But it's probably not good because the court does try to at least give you their reasoning. Right? They will bail out a pro se taxpayer, if in fact there was a theory here. In many cases, even if they weren't quite perfect in developing it, the court would still kind of say, okay, we can go with that. We understand they're pro se, don't understand this stuff. None of that was cut here. So again, our infographic, right? On the left side of the infographic, it's got the justification as to why staking rewards are gross income, right? In essence, power to dispose equal to ownership in this case, and it's a true accession to wealth. Once you have the undeniable accession to wealth under Section 61, That's income unless you can find another exclusion, right? There is, right? On the right side, it maps out the court's rejection of the more creative arguments. It clarifies why crypto awards, differ from non-taxable stock dividends. And it basically distinguishes the concept of, actually making property inventory for sale from this just kind of casual money comes in. In essence, they didn't cause the actual creation. That was simply the protocol, and they got picked and how much they got paid for doing it. It's not a self-created property like baking a cake, having a cake there, or having written a book. Those aren't the same. Okay, next let's go on to our sixth development. We're 6 of 7, so we're getting closer to the end, right? And in this case, we are going to be significant regulatory shift that affects exempt organizations that came from the One Big Beautiful Bill Act. IRS Notice 2026-36 announces the Treasury's intent to issue new proposed regulations regarding the 4960 excise tax on excess executive compensation for applicable tax-exempt organization, or ATEOs. Legislative catalyst for this notice is obviously the One Big Beautiful Bill Act last year. Under prior law established by the Tax Cuts and Jobs Act, a covered employee for purposes of excise tax was strictly limited to an organization's top 5 highest compensated employees. That top 5 rule is gone, right? And that legislation totally got rid of that limited scope. So, what we have in this case, let's take a look at this issue. Okay? So, as we note, the issue here is the One Big Beautiful Bill Act, what it did. And the key change here is covered employees being restricted to the 5 highest paid. That was the issue within the framework. However, under the OBBA, what's happened here is effective for tax years beginning after December 31st, 2025. So this year, the definition of a covered employee no longer is limited to an ATEO's top 5 highest compensated earners. Instead, the OBBA broadens the definition to encompass any employee of an ATEO, as well as any former employee who held such status during any taxable year beginning after December 31st of 2016. As you can imagine, this greatly expands this excise tax on those paid over $1 million, right? This is, again, on the not-for-profit side of the equation, right? A lot more could do it. In essence, it's not just 5. If you have a lot of people on the payroll that are highly paid, you may owe a lot of excise tax now. Previously, you limited it to the 5 most highly paid. Right? Section 3 and Section 4.01 of the notice here, it come up with a 2-tier transition system, right? These detail who will be captured as we transition to this new era. Tier 1, the first category, covers historical period. Any employee who is an active employee between 2017 and 2025 will permanently retain their covered status if they were a covered employee under the prior top 5 law. Tier 2 outlines the new post-2025 reality. Any individual who is an employee of an ATEO in any tax year beginning after December 1st, 2025 automatically joins the definition of a covered employee. So basically, formerly highly compensated individuals will keep their permanent status, while other employees will join them under the umbrella starting in 2026. Now, what about the anticipated regulations and exceptions? Notice outlines specifically structural changes we can expect in the forthcoming proposed regulations. First, the Treasury and the IRS will formally revise regulations by removing all references to the 5 highest compensated employees of the exempt organization. Fortunately, they intend to retain the existing exceptions for limited hours and non-exempt funds. However, a key protection will be eliminated, the limited services exception. The IRS reasons the original concern that motivated this exception, the potential displacement of an employee who could otherwise have ranked in the top 5 highest compensated list, is simply no longer relevant now that universal coverage applies. So that exception is going away. The other 2 will be retained in the final regs. So what's our interim reliance issue at this point? With this sweeping change, they know how to proceed right now, right? We need to know what's going to happen. Section 5.01 of the notice provides crucial interim relief, explicitly saying that organizations may immediately rely on the interpretations and rules outlined in Section 4.01 of the notice. The reliance period is valid until the forthcoming proposed regulations are formally issued. However, the immediate action items for practitioners is clear. You got to prepare your tax-exempt clients who have highly compensated individuals, more than 5, for a significant compliance shift. Require evaluating internal tracking mechanisms, since nearly all employees will soon fall under this regulatory umbrella. We'll need to test them. Okay. So here again, we have our infographic on this issue, right? Is an expansion. On the left side illustrates a shift from top 5 to everybody's in the net. Right? We're all there. That will apply to years after 25, so 26 and later. In the middle, the 2-tier transition rule is clearly defined. Right? We ended up with that, right, in that side. And finally, the right side outlines the key regulatory adjustments you need to know. Eliminating a limited service exception, the preservation of exceptions for limited hours and non-exempt funds. Immediately reliance ATEOs can place on this notice regarding pending formal regulations. Finally, we're going to be looking at a case involving the foreign bank account reporting requirements, right? This is United States versus Nixich. This is case number 2412882. In this case, it's an 11th Circuit Court of Appeals decision issued on June the 4th. Right? This was a high-stakes case in front of the court. This provides insights into the enforcement of foreign bank and financial accounts reporting requirements. Specifically, we're going to look at how the courts applied the objective standard for willfulness, the extreme dangers with relying on purported authority of the IRS agents during settlement negotiations. And then also the court sent back the case, though, for a decision from the trial court about whether the Eighth Amendment's bar on, let's say, on basically, extreme penalties is violated by this, that it does apply to this civil penalty. Okay, so let's start with the basic facts of noncompliance. Eugene Nixich failed to file a complete and accurate FBARs for years 2006 through 2012. He maintained foreign bank accounts at AKB Private Bank, Zurich AG, in Switzerland, and Banvivenda Banca Privada in Panama. The conduct surrounding these accounts showed a distinct lack of transparency. That's nice way of phrasing it. He held the Swiss bank account under the alias Misty. That was his dog's name. Right? While he intentionally concealed the account from his then wife, and even paid fees to have his bank statement sent to a U.S. address, specifically to maintain secrecy. Regarding his tax returns, which he self-prepared, he explicitly checked no on Schedule B in 2006 regarding foreign financial accounts and left the question completely blank in all later years. He eventually attempted to rectify through the IRS Offshore Voluntary Disclosure Program, the OVDP, but negotiations broke down. We have seen this many times. You decide to go in there, you have to realize that if you leave, you're likely going to face full enforcement action. So you better be darn sure when you leave, that you have a defensible position. So when he left, the IRS assessed a penalty of $2,286,954. Not exactly a cheap one, right? Shall we say? So what was his defenses? Facing a nearly $2.3 million penalty, the taxpayer raised several legal defenses. First, he challenged the willfulness finding, claiming his failure was due to a subjective misunderstanding of the law, believing non-trading investment assets didn't require reporting, and that he relied on professional advice. Second, he asserted an affirmative defense of accord and satisfaction, asserting the matter was officially settled because IRS agents had negotiated the Form 906 closing agreement and accepted a partial payment of roughly $331,375. Third, he raised an equitable estoppel defense, claiming the IRS committed affirmative misconduct by retaining those settlement funds while simultaneously repudiating the agreement. And finally, he argued a constitutional offense, asserting the massive penalties violated the excessive fines clause of the Eighth Amendment. As we will discover, only the fourth one is going to be one the court's going to say, yeah, that might actually apply. Trial court, we need you to go back and make a decision on this. So, the other ones didn't work out, so let's start with the standard for willfulness. And the 11th Circuit basically reaffirmed the willfulness standard for penalties, FBAR penalties, is strictly an objective standard, not a subjective one. Pretty much going along with the case law in other circuits. Citing United States versus Rum, the court noted that willfulness covers not just knowing violations, but reckless actions that carry an unjustifiably high risk of harm that is either known or so obvious it should be known. Applying this objective test to the facts, the court found that the taxpayer's behavior, using aliases to cover up his ownership of the account, actively hiding accounts from his family, and making blatant omissions on his self-prepared form on Schedule B, right? Answering it wrong one case, 1 year is saying, no, I don't need to, and then ignoring it. That's really, really tough to, ignore. The courts ruled the Schedule B questions are what get people into big trouble, because the court's going to say that, A, even if you had an outside person prepare it, which he didn't, he did himself, the existence of those questions should alert you to the fact that, there's some issue here if I have a bank account offshore. That's why they're there. And you're supposed to review the return. Saying, I didn't read it is never, ever, ever, ever worked. Just tell the client, basically, well, and I'll tell my clients, you're going to have to realize, don't just sign this thing and then come back a week later, which I've had clients do, and say, come back after signing it and returning it, and now the return has been submitted electronically. Now they come back and say, oh, well, what about this? It's like you were supposed to have read the return. That's why I say in my transmittal letter, you need to review this return and let me know if you see any issues or anything that might be omitted, or you have questions about the treatment of something. You need to do that. Well, here he did it himself. The court says you self-prepared. You knew that question was there. You answered it the first time. You should have followed up on that. That was there, right? A taxpayer's subjective belief they were in compliance or their subjective misunderstanding of the law is completely insufficient to defeat objective facts that demonstrate reckless conduct. You acted guilty. You acted as if you're doing something you shouldn't have been doing. And those all help convince us this was not just a simple, innocent misunderstanding. Next, we go to the limits of the IRS agent authority, right? This is a warning when you're in negotiations with the IRS, right? The limits of agency power. On the issue of accord and satisfaction, the court held the taxpayer could not bind the government because the negotiating IRS agents lacked the actual authority. Even though the taxpayer had signed a Form 906 closing agreement and made the partial payment of $331,000, the court noted the signature line for the Commissioner of Internal Revenue was conspicuously blank, never had been signed. Citing Fed Crop Insurance Corp versus Merrill, the court reminded practitioners anyone dealing with the government takes the risk of accurately ascertaining the agent's bounds of authority. These specific agents were simply receiving officers recommending acceptance, not officials who were actually empowered to bind the commissioner. Additionally, the court rejected equitable estoppel defense. Under TEFL versus Reno, an estoppel claim requires affirmative misconduct by the government. The court found that retaining the settlement funds after a mere informal refund request did not meet this high bar. Thus, no way to bind them to what the agents had suggested. It was, okay, yeah, we're going to recommend this be accepted. We'll want $330,000, we'll recommend it be accepted. It was not accepted when it went up the line. That's an issue. Now, there is a reversal here, major issue here, for constitutional protections in FBAR litigation. The 8th Circuit reversed the district court on this issue, ruling that FBAR penalties are indeed subject to constitutional scrutiny under the excessive fines clause of the 8th Amendment. And this follows a recent precedent set in 2025 case of United States versus Schwarzbaum. As a result, the court remanded the case back to lower courts to develop a factual record comparing the magnitude of nearly $2.3 million penalty against the taxpayer's actual conduct and assets. The ultimate takeaway, therefore, is twofold. Subjective good faith will not save a taxpayer from objective facts showing recklessness. You must never assume the IRS settlement is final without verified evidence of the agent's authority to bind the commissioner. Those are two key issues. And finally, if you're litigating this, then yes, the 8th Amendment defense is still acceptable per the 11th Circuit. The court needs to deal with that. Okay, let's go in here now and take a look at our final infographic, right? On the left side, we remind you that highlight the compliance and willfulness standard, reminding you that willfulness is an objective standard requiring reaching the recklessness threshold. Subjective intent or personal misunderstanding of the law is not a valid defense against reckless conduct. When the other conduct you had, right, using aliases or omitting foreign accounts on self-prepared returns, shows essentially reckless conduct. You left it off intentionally. On the right side, this infographic covers settlement authority and constitutional rights. It illustrates the absolute necessity of verifying actual authority before trusting an IRS settlement. And it notes it's the vital holding that the Eighth Amendment's excessive fines clause applies to FBAR penalties. Well, this concludes a review of current federal tax developments for this week. And those you look at the slide, it should say June 8th. It didn't update the last slide. So it's June 8th, not June 1st. That was last week's stuff, right? So again, we unpacked these updates this week, right? From the change in the closing letter fee to increased expansive definition of covered employees under 4930, 60, and litigation updates involving the ERC and our confusing two cases that say exactly the opposite thing for our level to be testing, and the FBAR enforcement issues. So hope you have a good week this week. I should be able to get this week's update out, but I will be traveling to be speaking at the New Jersey Society of CPAs convention, doing tax updates, individual and business tax updates for the convention, 2 different sessions. So I'll be there for most of the next week. I'll be there in Atlantic City as the convention goes on, and I hang around. The one after next week, though, that one will be a little more interesting. I think I can get everything put together in Atlantic City, but I'll have to see if I get time because I'm coming back on Saturday. If I'll get time to actually get things recorded and uploaded, considering all the other stuff I'm probably going to be behind in after being gone for a week. So we'll hope we won't do that, but if not, I'll do an overview of the 2 weeks activity in the following week. But anyway, we look forward to next week seeing you back here again for more current federal tax developments.